think a lot of the time when people hear about judges interpreting the Constitution for the purposes of making a ruling, they tend to think that this is something sinister going on, like the Supreme Court justices are inflicting their will upon people by interpreting things in the Constitution. But this is a misunderstanding, because there's no way to read the Constitution without interpreting it in some way. What actually is jaywalking? Is it jaywalking if I just step my foot off the curb 1 second before the light turns green? We need to interpret the statute in order to understand what jaywalking actually is, let alone whether or not this person's guilty of jaywalking. Turns out pretty much everything is vague in that way. Given that we have to do some interpreting of these statutes, we're also going to need some guidelines or principles for what the interpretation should look like, how to do the interpreting. The idea that we should think about what the words mean to the common reader today is known as living constitutional theory. On this view, the words mean something today to people in a way that they might have meant something different 100 or 200 years ago, and that it's the current meaning that should have the most weight. There's some intuitive appeal to living constitutionalism, as it seems to match our intuitions about the way laws change, morals change, customs change over time. An example of why we might need a living constitutional theory would be that when the First Amendment was first written, the freedom of the press could only have referred to printed objects. Today, of course, we think of journalism broadly as including broadcast media and internet media, and there's no particular reason why we should limit constitutional protection of journalists only to print media in a world where broadcast and internet media are real things. Living constitutionalism allows for the evolution of our understanding of what media is to include the protections of media to modern-day technologies. Another way of thinking about it is the so-called originalist theory, in which we focus on the meaning of the words at the time that the statute was written. For example, the Eighth Amendment rules out cruel and unusual punishments. But this raises the question, what do you mean cruel and unusual? Today, many people might think that capital punishment is cruel, and therefore it should be thought of as unconstitutional. But at the time that the Constitution was written, capital punishment was fairly commonplace and was probably not likely to have been regarded as either cruel or unusual. Even amongst originalists, there's differences of opinion about what it is that we're focused on. Some people think that we should be more interested in the original meaning of the words to the authors. Others think that we should be more interested in the original meaning of the words to contemporary audiences. And both of these would be distinct from the idea that we should care about the intention of the authors. If we understand the Constitution as a document that carefully enumerates the government's powers, then we're going to have some kind of originalism to help it do its job.